Chapter 8. Spain, a monarchy appointed by a dictator. The Spanish monarchy occupies a singular and unique place in the European pantheon. The British attempt to conceal the German origin of their dynasty behind patriotic signboards. The Danes pretend that their Glucksbergs are ancient kings and not appointees of the great powers. The Swedes have forgotten entirely that the founder of their dynasty was a revolutionary French general who bore the words "death to kings" tattooed upon his body. But the Spaniards have surpassed them all. For the Spanish monarchy is the only monarchy in Europe that was restored not by parliament, not by popular vote, not by international treaty, but by the personal will of a dictator. Francisco Franco, Caudillo of Spain by the grace of God and his own tank divisions, personally appointed Juan Carlos as his successor. He did so in 1969, 6 years before his own death, and did so in defiance of all the laws of dynastic law, in defiance of the rights of the lawful heir, Juan Carlos's own father, Don Juan, Count of Barcelona, and in defiance of the very idea of monarchy as an institution that exists independently of the will of temporary potentates. The Spanish Bourbons are not an ancient dynasty restored to its rights after a temporary interruption. They are puppets, placed upon the throne by a dictator and retrospectively legitimized by a constitution written under the supervision of Francoists. They rule a country that is formally a parliamentary monarchy, but whose constitution still retains Article 57, which discriminates against women in the right of succession to the throne, a disgraceful anachronism that the European Union has criticized for years, but which the Spanish elites dare not touch, because it forms part of the fragile compromise upon which the entire post-Francoist political edifice rests. In this chapter, we shall dissect the Spanish monarchy according to all the criteria of classical legitimacy, and the result shall perhaps be the most devastating of all. For if other dynasties at least attempt to simulate antiquity and continuity, the Spanish Bourbons can lay claim to not even that. Their history is a history of ruptures, usurpations, civil wars, and corruption scandals beside which even the exploits of the British Prince Andrew grow dim. 8.1. The Bourbons, a dynasty of 3 deaths and 3 resurrections. The Spanish Bourbons have formally ruled Spain since 1700, when the grandson of Louis XIV, Philip of Anjou, ascended the throne of Madrid under the name Felipe V, following a long and bloody war of the Spanish succession. This beginning alone ought to alarm any legitimist. The dynasty came to power not by right of blood, but by the testament of the childless King Charles II, whose will was disputed by half of Europe and confirmed solely by force of arms. Yet even if one closes one's eyes to this dubious commencement, the subsequent history of the Bourbons in Spain is a chronicle of unbroken catastrophes, ruptures, and restorations, each of which has only compounded their illegitimacy. The first rupture occurred in 1808, when Napoleon invaded Spain, forced Charles IV and his son Ferdinand VII to abdicate the throne, and seated his own brother, Joseph Bonaparte, upon it. The Bourbons returned in 1814, after Napoleon's defeat, yet this return was not an act of right, but the result of the military victory of the anti-French coalition. Ferdinand VII, ascending the throne, immediately abolished the Constitution of 1812 and established a regime of brutal reaction, which, however, did not save his dynasty from a new rupture. The second rupture arrived in 1868, when the revolution known as La Gloriosa overthrew Queen Isabella II. The Bourbons once more lost the throne, this time for 6 years. At the head of this coup stood General Juan Prim, a figure whom Spanish historiography prefers to skirt, because his actions lay bare the entire artificiality of the monarchical tradition. Prim did not simply overthrow the queen. Having become prime minister, he personally embarked upon a tour of the European courts in search of a new king for Spain. As if the crown were not a sacred symbol, but a vacant post for which a suitable candidate must be found. He is credited with a cynical phrase that perfectly characterizes the entire carnival. To seek a democratic monarch in Europe is like seeking an atheist in heaven. After lengthy haggling, the choice fell upon Amadeo of Savoy, the son of the Italian king. Prim personally persuaded the Cortes to vote for this candidacy. And then, on the 27th of December, 1870, on the very day Amadeo arrived in Spain to occupy the throne, Prim was mortally wounded by unknown assailants and died 3 days later. This is no restoration of monarchy. This is human resources policy, conducted at gunpoint. The Spanish throne in 1870 was not inherited by right of blood, but awarded by a revolutionary general acting in the name of the nation, yet in fact, as a military dictator. And this precedent forever deprives the Bourbons of any right to speak of historical legitimacy. In 1874, a military coup under General Martinez Campos restored the monarchy, placing Isabella's son, Alfonso XII, upon the throne. Yet this was no restoration of right. It was a military putsch, draped in a monarchist flag. The Spanish crown once more became, not a hereditary right, but a trophy, handed by the victorious faction of the Generalate to a convenient candidate. The third rupture was the most catastrophic. In 1931, after municipal elections in which the Republicans triumphed in the major cities, Alfonso XIII departed the country without even formally abdicating. The Second Spanish Republic was proclaimed. The Bourbons lost everything. They became exiles, living on the charity of relatives and pining for their former grandeur. From the standpoint of classical dynastic law, a republic constitutes a break in dynastic continuity. A crown cannot be temporarily suspended. It either exists or it does not. And if it has ceased to exist, it can be restored only by a new act of constituent power, for example, a constituent assembly convened by the people, but not, by any means, by the personal will of a dictator. And yet, this is precisely what occurred. In 1947, Francisco Franco, the victor of the Civil War, the dictator who ruled Spain with an iron fist, passed the law of succession to the headship of state. This law proclaimed Spain a kingdom, but left the post of head of state in Franco's hands for life. There was no king. There was the caudillo, who promised that someday, in an indefinite future, he would restore the monarchy. Upon what terms? Those that he himself would establish. By what right? By the right of the victor in a civil war. In 1969, Franco at last named a name. He proposed to the Cortes, the puppet parliament of his regime, that they confirm Juan Carlos de Bourbon as Prince of Spain and his future successor. Note the juridical construction, not heir to the throne, but successor to the headship of state. Franco was careful to avoid any acknowledgement that he was restoring the monarchy in a dynastic sense. For him, Juan Carlos was merely a continuation of his own power, his political heir, who was to preserve the regime after the caudillo's death. The choice fell upon Juan Carlos, and not upon his father, Don Juan, Count of Barcelona, for one simple reason: Don Juan was too independent. He criticized Franco, spoke in favor of democratic reforms, and refused to be a pawn in the dictator's hands. Juan Carlos, by contrast, was raised at the Francoist court, passed through all 3 military academies, and swore an oath of loyalty to the principles of the national movement. Franco was certain he had raised an obedient heir. That Juan Carlos, after the dictator's death, betrayed his expectations and began democratization is a separate story, but from the standpoint of dynastic law, it carries no weight. What matters is this: the man who became king of Spain in 1975 received the throne not by right of blood, but by appointment of a dictator. His own father, the lawful heir of Alfonso XIII, was alive and did not formally renounce his rights until 1977, meaning that, for 2 years, Juan Carlos ruled as a usurper even by the internal standards of the Bourbon family itself. This is not a monarchy. This is a dictatorship dressed in monarchical robes. This is usurpation squared. First, Franco usurped power from the Republic. Then he appointed a king, usurping the rights of the lawful heir. And the entirety of subsequent Spanish democracy, all the constitutional reforms, all the membership in the EU and NATO, all of this rests upon this rotten foundation. A foundation laid by a dictator who believed that monarchy was merely a convenient form of government, to be turned on and off at one's own discretion. 8.2. The Pragmatic Sanction of 1830. How one king broke dynastic law for his daughter. To understand why the Carlist Wars tore Spain apart throughout the 19th century, why the Bourbon dynasty never achieved stability, one must return to a single document that stands as a classical example of how one must not treat dynastic law. This is the Pragmatic Sanction, issued by King Ferdinand VII on the 29th of March, 1830. Ferdinand VII, one of the most repugnant characters in Spanish history, cowardly, treacherous, cruel, found himself faced with a problem. He had no children. 3 marriages had yielded no heir. His brother, Don Carlos, was impatiently awaiting Ferdinand's death so as to inherit the crown. According to the Salic law introduced into Spain by the first Bourbon, Felipe V. In 1713, women could not inherit the throne. Don Carlos was, therefore, the lawful heir. Yet in 1829, Ferdinand married for the fourth time to Maria Cristina of Bourbon, Two Sicilies. In October 1830, a daughter, Isabella, was born to them. Ferdinand, desiring to transmit the throne to his own progeny rather than to his brother, resolved to change the law. He recalled that his father, Charles IV, had supposedly approved a return to the old Castilian law in 1789, which permitted female succession, but this act had never been published and never entered into force. Ferdinand VII simply published it retroactively, 41 years after its alleged adoption. This was an act of pure arbitrariness. Ferdinand VII had no right to alter the fundamental law of succession at his own whim. Dynastic law is not the personal property of the monarch, which he may bequeath to whomever he pleases. It is an objective order, existing independently of his will. When Ferdinand issued the Pragmatic Sanction, he violated this order. He stole the crown from his brother and handed it to his daughter, and Spain paid for this with a sea of blood. Scarcely had Ferdinand died in 1833 when Don Carlos refused to recognize the Pragmatic Sanction and proclaimed himself King Carlos V. Thus began the First Carlist War, 1833 to 1840, a brutal civil war in which tens of thousands of Spaniards perished. The Carlists, supporters of Don Carlos, fought beneath the banner of Dios, Patria, Rey, God, Fatherland, King, and defended not merely the rights of a concrete claimant, but the very principle of legitimacy. The crown cannot be transmitted to a woman, Salic law is inviolable, and the will of a monarch cannot alter the fundamental order of succession. The Carlists lost the war, but they did not vanish. They continued their struggle throughout the entirety of the 19th and 20th centuries. The Second Carlist War, 1846 to 1849. The Third Carlist War, 1872 to 1876. And even in the 20th century, during the Civil War of 1936 to 1939, the Carlist militias, the Requetes, fought on Franco's side, hoping that the dictator would restore the lawful monarchy. They were mistaken. Franco betrayed them just as he betrayed all his allies. He chose Juan Carlos, the descendant of Isabella, that is, of the very line that the Carlists had regarded as usurpers since 1833. From the standpoint of classical dynastic law, the Carlists were right. The Pragmatic Sanction of 1830 was unlawful. Isabella II was a usurper. All her descendants, including the present King Felipe VI, sit upon a throne which by right ought to belong to the senior male line of the Bourbons, the line of the Carlist claimants. The Spanish monarchy is illegitimate not merely because it was restored by Franco. It has been illegitimate from the very year 1833, from the moment of Ferdinand VI's death. It merely required a century and a half of civil wars, dictatorships, and constitutional machinations to bury this fact definitively beneath a heap of propaganda. 8.3. The Constitution of 1978, ex post facto legitimation. When Franco died on the 20th of November, 1975, Juan Carlos was proclaimed king. Yet his position was juridically precarious. He was king by the will of a dictator, not by the right of inheritance. His father, Don Juan, was still alive and had not renounced his rights. Spain formally remained a kingdom without a constitution, governed by Francoist laws. Juan Carlos made an astute political move. He understood that the only means to retain the crown was to break with Francoism and assume leadership of the democratic transition. In 1976, he appointed as Prime Minister Adolfo Suarez, a former Francoist functionary who unexpectedly proved to be a skillful reformer. In 1977, the first free elections were held. In 1978, a new constitution was adopted and approved by referendum. The Constitution of 1978 is the document that legitimized the Spanish monarchy retroactively. Article 57 proclaims, "The crown of Spain shall be inherited by the successors of H.M. Don Juan Carlos I de Bourbon, the legitimate heir of the historic dynasty." Note this formulation, the legitimate heir of the historic dynasty. This is a direct lie. Juan Carlos was not the legitimate heir. The legitimate heir was his father, Don Juan, who ceded his rights to his son only in 1977, under the pressure of political circumstances, after realizing that otherwise the monarchy simply would not survive. Yet even if one were to forget Don Juan, the very idea that a constitution may proclaim Someone the legitimate heir is absurd from the standpoint of dynastic law. The legitimate heir is not he whom a constitution names. The legitimate heir is he who possesses the right by blood, by the dynastic laws that existed prior to all constitutions. The Constitution of 1978 did not restore a monarchy. It created a new monarchy, tying it to the person of Juan Carlos and his descendants. This is no restoration. This is a fabrication. And within this fabrication, disgraceful anachronisms have been preserved. Article 57.1 of the Spanish Constitution still states that, in the succession to the throne, the male shall have preference over the female, in the same degree of kinship. This is a direct violation of the principle of gender equality, entrenched both in that same constitution and in all international treaties signed by Spain. The European Union has repeatedly drawn Spain's attention to this discriminatory norm. Yet Spanish politicians are afraid to touch this question, because any amendment to the constitution touching upon the monarchy requires a complex procedure, the dissolution of parliament, fresh elections, and a referendum. And a referendum on the monarchy, in a country where the memory of Franco is still alive and the Bourbons' corruption scandals never leave the front pages, is Russian roulette for the crown. In 2005, when the then Prince Felipe and his wife Letizia had their daughter Leonor, the Zapatero government initiated consultations on reforming Article 57. Yet matters never progressed beyond talk. In 2007, a second daughter, Sofia, was born. The question of succession hung suspended in the air. Had a son been born to Felipe, he would automatically have become the heir, displacing his elder sisters. Only in 2014, when Felipe ascended the throne and no son had appeared, was Leonor proclaimed Princess of Asturias, the heiress to the throne. Yet the discriminatory norm in the Constitution remains. It awaits its hour, and that hour shall come, should a younger brother ever be born to Leonor. The Spanish monarchy prides itself on its modernity, on its role in the democratic transition, on its integration into Europe. Yet it still carries, in its fundamental law, the birthmark of Francoism and medieval obscurantism. It cannot rid itself of it, because any touch upon the constitutional foundations of the monarchy threatens to bring down the entire edifice. And it prefers to live with this disgrace, affecting that all is in order. 8.4. The corruption scandals of Juan Carlos, the pensioner king on the run. If the juridical illegitimacy of the Spanish monarchy requires a certain immersion in history and law, its moral decay is visible to the naked eye. And the chief symbol of this decay is Juan Carlos I, a man whom Spaniards for decades called the savior of democracy, and who ended his public life as a fugitive from justice, an exile who abandoned his country beneath a load of corruption allegations. The story of Juan Carlos's fall is a classical tragedy in which the hero outlives himself and turns into a caricature. The man who, in 1981, single-handedly halted a military coup by going before the television cameras in the uniform of Captain General and ordering the rebels to surrender, found himself, 20 years later, embroiled in scandals of such magnitude that even the most faithful monarchists began to avert their eyes. In 2012, at the height of a devastating economic crisis, when millions of Spaniards were losing their jobs and their homes, and the government was introducing austerity measures, Juan Carlos traveled to Botswana to hunt elephants. This safari cost tens of thousands of euros. It was organized by Karina Zuseyen-Wittgenstein, a German aristocrat and businesswoman whom the Spanish press termed the king's close friend. The trip became known only because the 74-year-old monarch suffered a fall, broke his hip, and was urgently transported to a Madrid clinic. A scandal erupted. The king, leaving the hospital, uttered a phrase that has entered the annals of Spanish political cynicism. Lo siento mucho. Me he equivocado y no volverá a ocurrir. I am very sorry. I was mistaken, and it shall not happen again. The Spanish branch of the World Wildlife Fund, WWF, of which Juan Carlos had been honorary president since 1968, convened an emergency meeting. 94% of the delegates voted to abolish the post of honorary president. The king who hunted elephants was expelled from a conservation organization. This was a public humiliation such as the Spanish crown had not known since the exile of Alfonso XIII. Yet the elephant hunt was merely the tip of the iceberg. In 2018, Swiss prosecutors opened an investigation into accounts linked to Juan Carlos. It emerged that, in 2008, King Abdullah of Saudi Arabia had transferred $100 million to the account of the Panamanian Foundation Lucum, of which Juan Carlos was the beneficiary. $65 million of that sum the king gave, in 2012, to Karina Larson, the very woman with whom he had hunted elephants. The investigation connected these funds to the contract for the construction of the high-speed railway between Mecca and Medina, a contract worth €6.7 billion, awarded to a consortium of Spanish companies with the personal assistance of Juan Carlos. In March 2020, when the scandal reached its zenith, King Felipe VI publicly renounced his inheritance from his father and stripped him of his annual allowance of €194,232. In June 2020, the Supreme Court of Spain opened an investigation into Juan Carlos. And in August 2020, the former king, without awaiting questioning, fled Spain. He departed for the United Arab Emirates, a country renowned for the absence of extradition in such cases. In a letter to his son, he wrote that he was leaving in order to facilitate Felipe's exercise of his functions. The Spanish political scientist José Núñez Seixas termed this not self-exile, but flight from the law and from Spanish public opinion. Prime Minister Pedro Sánchez declared himself disturbed by the revelations about the former king. But matters went no further than words. In March 2022, the Supreme Court of Spain shelved the investigation into Juan Carlos, citing the expiry of the statute of limitations, the immunity he had enjoyed until 2014, and insufficient evidence. The former king returned to Spain, attended a regatta, met with his son, and departed once more for Abu Dhabi. He was not convicted. He was not acquitted. He simply remained in a juridical limbo, a wealthy old man, living off money whose origins he has never been able to explain, in a country that asks no superfluous questions, such as the moral profile of the Spanish monarchy. A king receiving $100 million gifts from a Saudi dictator and dispensing a portion to his mistress. The honorary president of the Spanish branch of the WWF since 1968, an organization whose mission is the preservation of wildlife, personally traveling to Africa to shoot several elephants. And while Spaniards stood in queues for unemployment benefits, their king posed with a rifle against the background of the carcass of an animal his very status bound him to protect. The foundation, unable to endure such cynicism, abolished the post of honorary president itself rather than retain its august patron. A king fleeing his country at the first signs of justice, and a king returning, when the danger had passed, to enjoy life once more on the proceeds of capital of murky origin. From the standpoint of classical monarchical legitimacy, the moral fall of a monarch is not merely a personal sin. It is an undermining of the institution itself. The king must be an exemplar. He must be above suspicion. His private life must be irreproachable, for he is no private person. He is the embodiment of the state. When Juan Carlos took millions from the Saudis, he was selling not merely his influence. He was selling the honor of the Spanish crown. He was trading in that which did not belong to him: the trust of the people, the history of the dynasty, the future of the institution. And the fact that the Spanish political system permitted him to evade accountability merely compounds the crime. The monarch cannot be above the law. If he is above the law, this is no monarchy, but tyranny. The Spanish Bourbons, restored by a dictator, legitimized by a manipulative constitution, basking for decades in the glory of the democratic transition, have ended with their most celebrated representative becoming a symbol of corruption, impunity, and moral decay. 8.5. The abdication of 2014. The king departs to save the dynasty. On the 2nd of June, 2014, Juan Carlos I announced that he was abdicating the throne in favor of his son, Felipe. On the 11th of June, the Congress of Deputies passed an organic law permitting the abdication, 299 votes in favor, 19 against, and 23 abstentions. On the 19th of June, Felipe VI was proclaimed king. We have already examined the phenomenon of abdication in the chapters on Britain and Denmark. Yet there is a particular cynicism in the Spanish case. Juan Carlos abdicated not because he was weary, like Margareta II, and not because he wished to marry a divorced American, like Edward VIII. He abdicated because his reputation lay in ruins, his name had become toxic, and the sole means of saving the dynasty was to remove him from the Zarzuela palace. This was no voluntary abdication. It was a political capitulation under the pressure of circumstance. From the standpoint of classical dynastic law, abdication is impermissible. A king cannot retire. He is king unto death. If he abdicates, he acknowledges that his authority is an office, not a sacred calling. Moreover, in the Spanish constitutional tradition, abdication requires a special organic law passed by Parliament. That is to say, Parliament must permit the king to depart. What is this, if not an acknowledgement that the king is the servant of Parliament? Legitimists, and above all the Carlists, do not recognize the abdication of Juan Carlos. For them, the lawful king of Spain remains either Juan Carlos himself until his death, or, depending on the particular branch of legitimism, one of the descendants of Don Carlos the Elder. Felipe VI is, for them, a usurper twice over, both because he descends from the unlawful line of Isabella II, and because he received the crown through an abdication that carries no force in dynastic law. 8.6. Juridical conclusion. A throne restored by a dictator, not by right. Let us draw the threads together. Let us apply the criteria of classical legitimacy to the Spanish monarchy. Criterion status explanation. Blood grossly violated the pragmatic sanction of 1830 violated Salic law. The Carlists dispute the rights of Isabella II's descendants. The line of Felipe VI descends from a usurping branch. Indigenat, native origin, grossly violated. The Bourbons are a French dynasty, placed upon the Spanish throne in 1700 by testament and by force of arms. Felipe V was the grandson of Louis XIV, possessed not a drop of Spanish blood, and spoke no Spanish. 300 years of rule do not annul foreign origin. Blood does not assimilate. Dynastic continuity grossly violated 3 ruptures: 1808 to 1814, the Napoleonic invasion; 1868 to 1874, the Revolution and the imported King Amadeo; 1931 to 1975, the Republic and Franco's dictatorship. The restoration of 1975 was the personal will of a dictator, not an act of right. Absence of morganatic marriages systematically grossly violated. Felipe VI is married to Letizia Ortiz, a journalist, a commoner, and a divorcee. This is a morganatic marriage from the standpoint of classical law. Their daughters, including the heiress Leonor, are the offspring of a morganatic union. The monarch is not the servant of Parliament. Grossly violated. The Constitution of 1978 created the monarchy as an organ of state. Parliament passed the law on abdication. Article 57 of the Constitution defines the order of succession. The king is the creature of the Constitution, and not the reverse. Moral authority destroyed. Juan Carlos I, while serving as honorary president of the Spanish branch of the WWF, hunted elephants at the height of an economic crisis, for which he was expelled from the organization, received $100 million from Saudi Arabia, maintained offshore accounts, fled from justice. Felipe VI publicly renounced his father's inheritance. The Spanish monarchy is not a monarchy in the classical sense. It is a hybrid institution created by a dictator, legitimized by a manipulative constitution, and corroded by corruption. The Bourbons forfeited their right to the Spanish throne 3 times, in 1808, 1868, and 1931. Their return in 1975 was not a restoration of right, but a political bargain struck by Franco to preserve his regime after his death. That Juan Carlos betrayed the dictator's expectations and led Spain toward democracy is his personal merit, but it does not render his dynasty legitimate. Felipe VI is perhaps an intelligent and restrained monarch, striving to keep his distance from scandal. He is attempting to salvage what remains of the crown's reputation. Yet he sits upon a throne that was stolen by his ancestors in 1833, lost in 1931, and returned by a dictator in 1975. His legitimacy is nil. His moral authority is undermined by the sins of his father. His future depends not upon the right of blood, but upon how much longer the Spaniards are prepared to tolerate this anachronism, a monarchy that is neither ancient, nor lawful, nor clean. And when the Spaniards take pride in their exemplary democratic transition, they forget that at the heart of this transition stands an institution founded upon a lie that Juan Carlos was the legitimate heir of the historic dynasty. A lie that the Constitution of 1978 restored the monarchy. A lie that the king can be above the law. The Spanish crown is no symbol of national unity. It is a symbol of how dictatorship, corruption, and juridical nihilism may coexist beneath the handsome signboard of a constitutional monarchy. 8.7. Dismantling the Bourbons from the Spanish throne, a judicial strategy for a citizen of Spain. This chapter has demonstrated The Spanish monarchy is illegitimate by every criterion of classical dynastic law. The Bourbons are a French dynasty, placed upon the throne of Madrid in 1700 by testament and by force of arms, possessing not a drop of Spanish blood. The Pragmatic Sanction of 1830, which violated Salic law, gave rise to a century and a half of civil wars and to the Carlist movement, which to this day disputes the rights of Isabella II's descendants. In 1931, the monarchy fell. The Republic was lawfully proclaimed. And in 1975, the crown was restored not by right of blood, not by the will of the people, not by a decision of Parliament, but by the personal will of the dictator Francisco Franco, who appointed Juan Carlos as his successor to the headship of state, bypassing his lawful father. The Constitution of 1978, for all its democratic merits, merely legitimized this usurpation ex post facto. And Article 57 of that Constitution still discriminates against women in the right of succession to the throne, a disgraceful anachronism that the European Union has for years demanded be altered. Add to this the moral decay. Juan Carlos I, honorary president of the Spanish branch of the World Wildlife Fund, WWF, expelled from that organization for hunting elephants at the height of an economic crisis. The recipient of $100 million from a Saudi king into a Panamanian account. A fugitive from justice, sheltering in Abu Dhabi. His son, the present King Felipe VI, has publicly renounced his father's inheritance in an attempt to salvage what remains of the crown's reputation. Now the question arises, what is a citizen of Spain to do with this knowledge? The answer is the same as for all the preceding countries: false suit. Yet the Spanish case possesses a unique characteristic. Here the plaintiff has not one, but three independent routes of attack: dynastic law, criminal law, constitutional law, and a blow may be struck along each. Why Spain is the most vulnerable major monarchy in Europe. Among all the European monarchies, the Spanish occupies a singular position. It is no young monarchy, like the Norwegian, which might be reproached for its lack of history. On the contrary, the Bourbons have a history, but it is a history of ruptures, usurpations, and civil wars. 3 times they lost the throne. Twice they returned upon bayonets. Once they were restored by a dictator. This history renders them uniquely vulnerable. The British may point to 300 years of continuity. The Danes to the myth of Europe's oldest dynasty. The Swedes to the Bernadottes, who have at least been popular. Yet the Spaniards can point to nothing. Their monarchy is a broken line, passing through Napoleonic invasion, republic, dictatorship, and corruption scandals. Each rupture annihilated legitimacy. Each restoration was an act of force, not of right. And today, with Juan Carlos living in exile in Abu Dhabi and his son attempting to scrub the family name clean of the stains of corruption, the Spanish crown hangs by a thread. One well-prepared lawsuit is sufficient, and that thread shall snap. In which court to file? The Spanish plaintiff has 3 parallel routes. Route 1, the Constitutional Court of Spain, Tribunal Constitutional. Article 57.1 of the Spanish Constitution still states that, in the succession to the throne, the male shall have preference over the female in the same degree of kinship. This is a direct violation of Article 14 of that same Constitution, which proclaims the equality of all Spaniards before the law without any discrimination on grounds of sex. It is also a violation of Spain's international obligations under the European Convention on Human Rights and the Charter of Fundamental Rights of the European Union. A suit seeking a declaration that Article 57.1 is unconstitutional may be filed by any Spanish citizen whose rights are violated by this article. For instance, a female lawyer arguing that the existence, in the fundamental law of the land, of a norm declaring women second-class heirs offends her dignity and violates her right to equality. Or a mother of 2 daughters, who may argue, had she had a son, he would automatically have received preference over the elder sister. And this is discrimination elevated by the Constitution to the rank of fundamental law. The Constitutional Court may declare Article 57.1 unconstitutional. This will not topple the monarchy immediately, but it will create a legal obligation for Parliament to amend the Constitution. And a constitutional amendment touching upon the monarchy requires a procedure that includes the dissolution of Parliament, fresh elections, and a referendum. A referendum on the monarchy in Spain is precisely what the Bourbons fear above all. Route 2, a civil suit against the state. To be filed in the National Court, Audiencia Nacional, or the Supreme Court, Tribunal Supremo. The subject of the suit, a declaration of the absence of legal grounds for the occupation of the throne by the Bourbon dynasty. The plaintiff, a Spanish taxpayer, whose money goes to the maintenance of the royal household. The argument: if the dynasty was restored by a dictator in circumvention of the lawful heir, then all acts issued in its name are null and void, and the expenditure upon its maintenance constitutes unjust enrichment. A special plaintiff along this route is a Carlist claimant to the Spanish throne. The Carlists have disputed the rights of Isabella II's descendants since 1833. The senior male line of the Bourbons still exists. Its present head, Sixto Enrique de Borbon Parma, or another recognized Carlist claimant, possesses ideal standing for such a suit. This is no abstract citizen discontented with his taxes. This is a man whose right to the throne was stolen by the Pragmatic Sanction of 1830 and the subsequent usurpations. The suit of a Carlist claimant is a dynastic dispute, which the Spanish courts will not be able to dismiss as a political question, for it is a question of the rights of a concrete person, founded upon the dynastic laws that existed prior to all constitutions. Route 3. Criminal and civil suit against Juan Carlos. Although the Spanish Supreme Court shelved the criminal investigation into Juan Carlos in 2022, this decision is not final in every respect. Firstly, a civil suit for the recovery of damages to the state may be filed independently of any criminal prosecution. The argument: Juan Carlos, as head of state, used his position to receive bribes, $100 million from the Saudi king, a portion of which was transferred to his mistress. These funds ought to have entered the Spanish treasury had they been lawfully obtained. That they ended up in Panamanian accounts constitutes direct financial damage to the Spanish state. The plaintiff, a taxpayer, may demand the return of these funds to the budget. Secondly, the decision to close the criminal case may be appealed to the European Court of Human Rights. The argument: the Spanish state, by refusing to prosecute the former king for corruption, violates citizens' rights to equality before the law, Article 14 of the Convention, and to an effective remedy, Article 13. If Spanish courts forgive corruption on the part of a former monarch, citing his immunity, then that immunity itself constitutes a violation of the Convention. Route 4. The European Court of Human Rights. After exhausting domestic remedies, a complaint to Strasbourg. Arguments: violation of Article 6, the right to a fair trial. If Spanish courts refuse to consider the suit on the legitimacy of the monarchy, Article 13, the right to an effective remedy. Article 14, discrimination, in the matter of Article 57.1 of the Constitution, as well as in the granting to a former king of an immunity unavailable to ordinary citizens. Article 1 of Protocol No. 12, the general prohibition of discrimination. Who may be a plaintiff? A Spanish taxpayer. Each year, the royal household receives approximately €8 million from the state budget. If the dynasty is illegitimate, these payments are made in favor of usurpers. This constitutes direct financial injury. A Carlist claimant. Sixto Enrique de Borbon Parma, recognized by the Carlists as the lawful king of Spain, or another representative of the senior male line of the Bourbons. His suit shall be a dynastic dispute over the right to the throne, founded upon Salic law and the non-recognition of the Pragmatic Sanction of 1830. The Spanish courts shall face an unprecedented situation. There shall stand before them a man whose ancestors were the lawful kings, and he shall demand the recognition of his rights. A woman, a victim of discrimination. Article 57.1 of the Constitution still discriminates against women. Any Spanish woman may file a suit in the Constitutional Court, arguing that this norm offends her dignity and violates her right to equality as guaranteed by Article 14 of that same Constitution. A Catalan or Basque organization. The separatist movements of Catalonia and the Basque Country have a particular interest in the dismantling of the Spanish monarchy. For them, a suit over the illegitimacy of the Bourbons is a means of undermining the legitimacy of the Spanish state as a whole. If the crown is illegitimate, then the state of which it is the symbol forfeits a share of its own legitimacy. Upon what to build the case? 6 pillars. Pillar the first, the Pragmatic Sanction of 1830. Ferdinand VII had no right to alter Salic law at his whim. The Pragmatic Sanction, issued by him to transmit the throne to his daughter in circumvention of his brother, was an act of arbitrariness and a violation of fundamental dynastic law. Don Carlos the Elder was the lawful heir. All subsequent monarchs descending from Isabella II are usurpers from the standpoint of Carlist legitimism. This question was never resolved, It was suppressed by force of arms in the three Carlist wars. Yet right is not determined by victory in a civil war. Pillar the second, appointment by a dictator. Juan Carlos became king not by right of inheritance, but by the will of Francisco Franco. The law of succession to the headship of state of 1947 proclaimed Spain a kingdom, but left Franco as head of state for life, with the right to name his successor. In 1969, Franco appointed Juan Carlos as his successor, bypassing his father, Don Juan, who was the lawful heir of Alfonso XIII. This appointment was an act of the dictator's pure political will, not a restoration of dynastic right. Don Juan formally renounced his rights only in 1977, 2 years after Franco's death. Consequently, from 1975 to 1977, Juan Carlos ruled as a usurper even by the internal standards of the Bourbon family itself. Pillar the third, the rupture of dynastic continuity. In 1931, Alfonso XIII departed Spain, and the Second Republic was proclaimed. From the standpoint of classical dynastic law, a republic constitutes a break in dynastic continuity. A crown cannot be temporarily suspended. It either exists or it does not. The restoration of the monarchy in 1975 was not a restoration of right, but the creation of a new monarchy, tied to the person of Juan Carlos. The Constitution of 1978, which proclaimed Juan Carlos, the legitimate heir of the historic dynasty, lied. He was not the legitimate heir. The legitimate heir was his father. Pillar the fourth, Article 57 of the Constitution, the discrimination of women. Article 57.1 of the Spanish Constitution still establishes that the male shall have preference over the female in the same degree of kinship. This is a direct violation of the principle of gender equality, entrenched in Article 14 of that same Constitution, in Article 14 of the European Convention on Human Rights, and in the Charter of Fundamental Rights of the European Union. The European Union has repeatedly criticized Spain for this norm. Spanish governments have promised to amend it, yet have not done so, fearing the opening of constitutional debates on the monarchy. The existence of this norm in the fundamental law of a democratic country is a disgrace, which the Constitutional Court has both the full right and the duty to eliminate. Pillar the fifth, the corruption of Juan Carlos and moral decay. Juan Carlos I, as head of state, received $100 million from the King of Saudi Arabia through a Panamanian foundation. A portion of these funds was transferred to his mistress. He hunted elephants in Botswana at the height of an economic crisis, for which he was expelled from the WWF, the very organization of which he was honorary president. He fled Spain for Abu Dhabi at the first signs of a criminal investigation. All of this constitutes documented facts, not rumors. A king stained by corruption on such a scale cannot be the head of state. Pillar the sixth, abdication as confession. Juan Carlos abdicated the throne in 2014 beneath the pressure of scandals. Parliament passed an organic law permitting the abdication. As we have already examined in the chapters on Britain, Denmark, and Sweden, abdication is incompatible with classical dynastic law. A monarch cannot go into retirement. If he abdicates, he acknowledges that his authority is an office, not a sacred calling. Moreover, when Parliament permits the king to depart, it thereby confirms the crown exists by the will of Parliament and not by divine right. Why the court will refuse, and why this does not matter. The Spanish court shall, in all likelihood, attempt to dismiss any of these suits. The Constitutional Court may declare that Article 57 forms part of the Constitutional Compromise of 1978 and cannot be altered by judicial means. The Supreme Court may invoke the political character of the question of the monarchy's legitimacy. The Carlist suit may be dismissed on grounds of the expiry of limitation periods. Yet it is precisely here that the Spanish case possesses particular force. Because the plaintiff has 3 parallel routes, and a refusal along one does not signify refusal along the others. Moreover, the very fact that the Spanish courts shall be compelled publicly to explain why they refuse to consider the question of the Bourbons' legitimacy, against the backdrop of Juan Carlos's corruption scandals, against the backdrop of a discriminatory article of the Constitution, against the backdrop of Carlist claims that have never been juridically resolved. This fact shall itself become a catalyst for the political process. Spain is a country with strong republican traditions. The Catalan and Basque separatists shall seize upon any argument that undermines the legitimacy of Madrid. The left-wing parties, Podemos, Sumar, have long demanded a referendum on the monarchy. The corruption scandals of Juan Carlos have already undermined trust in the institution. A suit filed at such a moment is not merely a juridical document. It is a match cast into a powder keg. A practical plan. Step 1. Find a Spanish lawyer specializing in constitutional law, human rights, and international law. They must understand that the aim of the proceedings is not immediate victory, but the creation of a public precedent and the catalyzing of the political process. Step 2. Prepare 3 parallel suits. A constitutional suit on the unconstitutionality of Article 57.1. A civil suit for a declaration of the absence of legal grounds for the occupation of the throne, and, if possible, a Carlist suit for the recognition of the rights of the senior male line of the Bourbons. Step 3. File the constitutional suit in the Constitutional Court and the civil suit in the Supreme Court or the National Court. Step 4. Upon the inevitable refusals, appeal, first within the Spanish courts and thereafter to the ECHR. Step 5. Coordinate the judicial process with the political one. Transmit all court documents to the Republican parties and the separatist movements for use in parliamentary debates. Every judicial decision must become a news peg. Step 6. Document each stage of the process. Issue press releases. Grant interviews. Use every court hearing as a platform for conveying the arguments to the Spanish public. To whom the throne shall fall. The Spanish monarchy cannot fall quietly. It has too many enemies and too few friends. When the hour comes, and it shall come, the Bourbons shall not be able simply to pack their bags and depart for Abu Dhabi in the wake of Juan Carlos. They shall be compelled to answer questions about the $100 million, about the Panamanian accounts, about the elephants killed in Botswana, about the pragmatic sanction that stole the throne from the lawful heir, about the dictator who appointed a king as one appoints a provincial prefect. And when these questions are put in a court of law, not at a rally, not in a newspaper article, but in a court where falsehood is punished by law, the Spanish crown shall collapse, not because the Spaniards are the most politically conscious, but because their monarchy is the filthiest. Spain shall be followed by the rest. The domino has already begun to sway. It remains only to file the suit.